Chapter 8, Child Custody. After reading this chapter, you should be able to identify various types of child custody, identify at least 3 jurisdictional issues that sometimes arise in child custody cases, describe the primary standards that guide the courts when making child custody decisions, including what's known as the best interest of the child, list some of the major factors courts consider when making decisions about child custody and visitation, describe the nature and purpose of parenting plans, explain why parent education programs are important, explain when and how custody and visitation orders may be modified, explain how custody and visitation orders may be enforced, describe the rights of third parties in the custody context, explain who speaks for the child in custody matters, and describe the role of the paralegal in a custody case. So first off, identifying various types of child custody. What are the various types of child custody? In traditional terms, there's physical custody, custody relating to where and with whom the child primarily resides. Physical custody may be joint or sole. There's also legal custody, custody relating to decision-making authority with respect to major issues affecting a child. This also may be sole or joint. A sole award of custody, an award made to one party only, may apply to physical or legal custody. And a joint award, an award made to both parents, may apply to physical or legal custody. Many states have adopted new terminology that emphasizes parental cooperation and a child-centered focus, for example, by calling physical custody residential responsibility and legal custody decision-making responsibility. Custody awards are tailored to the circumstances of each case. Absent evidence of unfitness, parents are generally considered to have equal rights to custody. The 2 most common custodial arrangements are joint legal custody, sole physical custody in one parent with reasonable rights of visitation in the other, joint legal and physical custody. Although not favored, courts sometimes will award split custody when appropriate. This is a situation where each parent has legal and/or physical custody of one or more of the party's children. So typically this would be a situation where you have not typically, but if you had, say, for example, 2 children, one child would reside with mother, one child would reside with father. That would be a split custody arrangement. The courts don't like those. They don't like to split the children up from their siblings. But there are some circumstances in which the courts will grant those. And when we talk about joint custody, typically in Ohio, that may be referred to as shared parenting, depending on the circumstances. But again, it depends on the circumstances, the type of order that you're talking about, and the designation of parental responsibilities in that order. Identify at least 3 jurisdictional issues that sometimes arise in child custody cases. Problems are minimal in cases in which the parents' identities are known and they reside in the same state. Problems are more likely to arise when the parents live in different states, or when one parent leaves the state where the parties have lived and takes the children with him or her without the other party's consent, where the parties file for custody in 2 different states, where during a visit a parent essentially kidnaps a child and takes him or her to another country, where a parent seeks to modify an existing custody order in a state different from the state where the original order was entered. In resolving problems that arise, the courts refer to several key acts, including the following 3. The Uniform Child Custody Jurisdiction and Enforcement Act, otherwise known as the UCCJEA, is adopted in all states. It's designed to reduce jurisdictional conflicts between states, to deter child abductions to other states, to avoid relitigation of decisions in non-issuing states, and ensure that custody matters are heard in the state with the closest connection with the child by giving priority to home state jurisdiction. There's also the Parental Kidnapping Prevention Act, known as the PKPA. The Major Federal Child Custody Jurisdiction Act is designed not only to prevent parental kidnapping, but also to maintain jurisdiction in one court over custody orders pertaining to a given child in interstate cases. The Hague Convention on the Civil Aspects of International Child Abduction, endorsed by more than 50 nations, establishes administrative and judicial procedures to expedite the return of children who have been abducted or wrongfully retained, and to facilitate the exercise of visitation rights across international borders. Describe the primary standards that guide the courts when making child custody decisions, including the best interest of the child. What are the 6 major approaches that have been used to guide custody decisions over the years? Early approaches included the following gender-biased approaches. There was paternal preference, where the common law doctrine stated that fathers had an absolute right to the care and custody of their children. There was the maternal preference, the concept that custody should be awarded to a mother over a father provided she is fit. And the tender years doctrine, which was the doctrine holding that custody of very young children should be awarded to the mother as the natural custodian of young and immature children provided she is fit. Contemporary gender-neutral approaches include the following. Best interest of the child, which is the majority approach today. This is the approach utilized in the state of Ohio. This standard focuses on the needs of the child over the rights or wishes of the parents. The states identify by statute or case law a series of, quote, best interest factors, end quote, for courts to consider when making custody determinations. The primary caretaker presumption, the concept that the individual who has performed most of the significant parenting tasks for the child since birth or in the years preceding the divorce should be granted custody. And the American Law Institute's approximation rule, the rule that the custodial responsibilities of the parents at dissolution should be allocated in a manner that approximates the proportion of time each parent spent caring for the child when the family was intact. List some of the major factors courts consider when making decisions about custody and visitation. Availability. This is a relevant factor because the courts consider whether or not parents are available to participate in activities with their children, such as school and recreational activities, medical appointments, homework, daily routines, etc. Stability. Courts strive to maintain as much stability and continuity in parenting arrangements as possible to avoid disruption for the child. Gender. The public policy of virtually all states is that fit parents have equal custody rights regardless of gender. Race. The Equal Protection Clause of the Constitution prohibits the making of custody decisions based on racial bias. Religion. The majority of courts have affirmed each parent's right to freedom of religion and to parent a child by providing religious exposure and instruction as he or she sees fit unless the child is being harmed. Parental health or disability. Poor mental or physical health will not necessarily render a parent unfit. The courts will examine the, quote, nexus, end quote, between the condition and the parent's capacity to provide proper child care. Sexual activity. The majority view is that a parent's sexual behavior or cohabitation should not play a role in a custody decision unless there is a connection between the behavior and the health and welfare of the child. Tolerance is higher for heterosexual relationships. Parental lifestyle. Based on statutes and case law, moral character and conduct count under some circumstances. The critical question is, does a behavior such as smoking harm the child, as in the case of an asthmatic child? History of abuse. Each state provides by statute or case law that a history of domestic abuse will be considered in custody determinations. Some states have a rebuttable presumption against granting custody to a parent who is a documented perpetrator of domestic violence. There's actually in the child custody affidavit that is a standard form affidavit that has to be filed with the court when you initiate parenting proceedings or divorce proceedings. There is a question in the custody affidavit that asks whether either party has been subject to criminal prosecution for any acts of violence against children. So that's one of the ways in which the court helps to safeguard children. Child preference. Today, children's preferences may be considered to some extent in all states. The weight given to a child's choice usually will be based on the child's age, experience, maturity, judgment, and ability to express a preference. We will still, and you will probably in your practice, have people who will call and ask at what age a child can choose which parent they want to live with. It used to be the law in the state of Ohio years ago that a child could choose which parent they wanted to live with. That has not been the law for some time, but people still have that notion in the back of their mind that a child is able to choose which parent they want to live with. The child is able to state a preference if they are of sufficient age and maturity to do what they typically do it as either an in-camera interview, or the preference would be stated to a guardian ad litem, and it becomes part of the determination of the best interest of the child, but it is not a determining factor. Parental cooperation. Courts will look at the extent to which each parent has the capacity to rise above his or her own desires and hostility to focus on the child's need to maintain a warm and positive relationship with both parents. Describe the nature and purpose of parenting plans. A parenting plan is a written agreement in which the parents of a child lay out plans for taking care of their child or children post-separation or post-divorce. It may be in the form of a document called a parenting plan or in the form of custody and child support exhibits in a separation or marital agreement. When joint custody or shared parenting is not desirable or feasible, the parenting plan will typically address visitation arrangements with the non-custodial parent unless it would pose a threat to the child's health and welfare. There are no fixed formulas for visitation provisions. They are shaped primarily by the degree to which the parents are able to communicate about the children's needs and schedules, appropriate parenting behaviors, and goals for the children's welfare. They may reflect input from the children based on their ages and maturity levels. Visitation schedules range from highly detailed provisions to flexible, open-ended arrangements. Most fall somewhere in between. Agreements or plans may include a virtual visitation component, communication with children through the use of technology. Most visitation is unsupervised, but the courts may order supervised visitation in appropriate circumstances, for example, where there's been a history of domestic abuse. There is an example on pages 427 to 433 of your text of some sample separation agreements with provisions for parenting time. I want to back up really quickly. Just while it states there are no fixed formulas for visitation, the courts in Ohio do have standard parenting schedules provided that if the parties are not entering into shared parenting, or even if they are entering into shared parenting, there is a minimum amount of visitation that the non-custodial parent is entitled to. These are the standard rule visitation schedules. It's Rule 28 in Franklin County. There are provisions for parents who live within 90 miles of one another or parents who live outside of that distance, and it provides a detailed schedule of how visitation is to occur and how the holidays are to be divided, etc. So there is a formula to some extent, but when you're dealing with shared parenting plans, they really are open to anything that the parties want to agree to. You can have a shared parenting plan that is really shared parenting in name only. It gives the parents joint decision-making authority, joint access to records, those types of things. Essentially puts the parents on an equal footing, but it doesn't mean equal time. Shared parenting can be the standard rule visitation, which is the absolute minimum the court typically will award in circumstances where you have two fit parents, but you can call it shared parenting. So there are minimum visitation schedules. Again, be aware of that going forward. Those schedules are available online in the domestic relations and juvenile court forms. You can look for those standard parenting visitation schedules. Parenting plans are designed to promote cooperative planning, minimize disputes and continued hostility over parenting issues, provide for the children's care, maintain the child's emotional stability, provide for the child's changing needs as they grow and mature, minimizing the need for modifications. They set forth the authority and responsibilities of each parent with respect to the child. They minimize the child's exposure to harmful parental conflict and otherwise protect the child's best interest. Parent education programs and their primary purpose. Many states, Ohio included, require divorcing, separating parents to complete a parent education program designed to sensitize them to the needs and feelings of their children who are impacted by their parents' divorce. Primary purposes of the parent education programs are to encourage parents to work cooperatively for the benefit of their children, to help children through the difficult period of divorce and separation, to reduce post-divorce litigation and court appearances. Parents usually attend different sessions, and waivers of participation may be obtained in limited circumstances, such as where there is a history of abuse. What topics does the curriculum of a parent education program commonly address? The emotional effects of divorce on parents and children, what parents can do to help their children adjust, communication and co-parenting skills, developmental stages and needs of children, factors that contribute to a child's healthy adjustment, techniques of problem solving and conflict resolution, warning signs that children are having problems, available community resources, and the function and value of parenting plans. Explain when and how custody and visitation orders may be modified. The usual process for modifying custody involves filing a motion for modification of custody, typically accompanied by a supporting affidavit in the court that has continuing jurisdiction, followed by notice to the other party and a hearing in which each party has an opportunity to testify, call witnesses, and offer other evidence in support of their position. Typically, a party seeking to modify a custody order must show that there has been a substantial and material change in the circumstances that affects the child's welfare. The change has occurred since the entry of the decree and was not foreseeable at the time of the prior decree, or the time that the prior order was entered into. They have to establish that the change warrants a modification of custody and that the change will be in the child's best interest. Motions for modification are likely to be granted if the parties agree to the modification, if it is clear that the initial allocation of parental rights and responsibilities is not working, if there is clear and convincing evidence that the child's present environment is harming him or her physically, mentally, is harming his or her physical, mental, or emotional health, if there is repeated, intentional, and unwarranted interference by one parent with the parenting rights and responsibilities of the other parent, if there is a change in one of the parent's circumstances that significantly affects his or her fitness and availability as a parent. Relocation cases present a special challenge. The trend is to permit them if satisfactory alternative parenting times can be arranged for the non-custodial parent. There are no bad faith motives for the move, and the relocation will be in the child's best interest. Explaining how custody and visitation orders may be enforced. When a parent fails to comply with court-ordered custody and visitation provisions, the wronged parent will usually file a complaint for contempt and potentially one for modification of both custody and child support as well. The court may find the defendant parent in contempt and has the power to order them to pay a fine or go to jail or both. The court most likely will modify custody, impose conditions on visitation, award attorney's fees to the other party, and in especially egregious cases deny visitation. So basically, when you are looking at the enforcement of any order, any court order, you're typically looking at a motion in contempt, and visitation orders are no different. Sometimes they are simply a motion in contempt. Sometimes if the conduct arises to such that it has interfered with custody to a substantial degree, or is based on some significant change in circumstances, then it would warrant the filing of a motion to modify the parenting schedule as well. Describe the rights of third parties in the custody context. Nearly 14 million children in the U.S. live with parties other than their parents, and that number continues to grow. Those parties include surrogate parents, de facto parents, psychological parents, and foster parents, among others. There are two competing views regarding custodial and visitation rights of third parties. One is the view that biological parents have a presumptive right to custody of their children and to parent them as they see fit. There's also the view that it is in the best interest of the children to be placed with whichever adult will provide the healthiest and most stable environment for the child. Standing of third parties to seek custody or visitation is usually established by statute or case law. If a party, typically a party filing to intervene in a custody case or to seek visitation, most often these are going to be unmarried fathers, step-parents, grandparents, or co-parents. Unmarried fathers do not have the same rights and obligations as married fathers. Many unmarried fathers have tried but have been thwarted in their efforts to be fathers to their children, and they have become, in effect, third parties, while other fathers have knowingly failed to acknowledge fatherhood in a timely manner. The states vary in their approaches to unmarried fathers, ranging from setting a fixed window within which fathers must establish paternity to an approach tailored to the facts of the individual cases. Step-parents, it's estimated that 1 in 4 children will live with a step-parent before reaching the age of majority. The law is unclear and inconsistent with respect to the rights of step-parents. The majority view is that a step-parent's rights flow from the marriage to the child's parent and do not survive divorce. The minority of states impose financial obligations on step-parents in limited circumstances, such as when they have voluntarily supported their stepchildren. Ohio is not a state that imposes any obligation upon step-parents upon the termination of a marriage. A limited number of states afford step-parents standing to petition for custody and visitation in some circumstances, often struggling to find legal theories to support their efforts to play a role in their stepchildren's lives. You can look at the case of McAllister versus McAllister on 282 to 283 of your text for a case in which a stepfather was in fact granted visitation rights with a stepchild. Grandparents. In 2009, nearly 12% of all children were living in households with at least one grandparent present. Under common law, grandparents had no standing to petition for custody or visitation of their grandchildren. Now legislatures in every state provide standing for grandparents to petition for custody and visitation rights in some circumstances. After the Supreme Court's decision in Troxell v. Granville, look at case 8.4 on 284 to 285 of your text. There's a presumptive validity must be given to a fit parent's objection, and the grandparent must establish more than that visitation will be in the child's best interest. They must essentially show that refusal to grant visitation will cause significant harm to the child's health, safety, and welfare. So that has been a significant limitation on the rights of grandparents to petition the court for visitation with grandchildren. Co-parents. A co-parent is a person who is engaged in a non-marital relationship with the legal parent of a child and who regards himself or herself as a parent rather than as a legal stranger to the child. Some co-parents adopt the child to protect their rights and obligations with consent of the legal parent. Co-parents rely on a variety of legal theories to maintain a relationship with a child they have helped raise after the relationship with the child's legal parent has ended. Decisions are mixed in cases involving same-sex co-parents. Many states deny standing as parents but afford third-party status as a person with a significant relationship to the child. So it would be essentially like a grandparent seeking visitation with some states with same-sex partners. Who speaks for children in custody matters? Those who speak for children include the following: guardian ad litem, otherwise known as a GAL. A GAL is a neutral evaluator appointed by the court, often at the request of one or both parents, but the court can, on its own motion, appoint a guardian ad litem as well, to assess the interest of the children whose custody is in dispute. The guardian may be an attorney, social worker, or a psychologist. Typically in Ohio, they're going to be attorneys. The primary role of the GAL is to examine the child's situation as fully as possible and make a recommendation to the court. There are also court-appointed special advocates known as CASAs. The CASA volunteer is a court-appointed volunteer advocate who works one-on-one with abused and endangered children. Typically, you're going to see the involvement of a CASA advocate in abuse, neglect, dependency cases in the juvenile court. What is the role of the paralegal in a custody case? The major tasks performed include researching the law governing custody actions in the jurisdiction, scheduling and participating in interviews as assigned, gathering information and documentation as requested, drafting formal discovery materials, and conducting informal discovery as directed. The major tasks performed include drafting correspondence, pleadings, motions, affidavits, etc., involving custody matters, drafting parenting plans, custody exhibits, assisting in preparation for hearings and trials, etc., coordinating communication with experts, parenting coordinators, GALs, CASA volunteers, etc. So that is child custody in a nutshell. Stay tuned for the lecture on chapter 9. Thank you all.